Good evening. I would like to welcome you to our panel discussion this evening on operating agreements, hosted by the City of Los Angeles's Department of Cannabis Regulation. My name is Natalie Darvis, and I am the chair of the Business Department of Oaksterdam University, the first and longest running cannabis college in the world. And I'm thrilled to be your moderator this evening. We are here tonight because the Department of Cannabis Regulation has officially launched the Business Licensing and Compliance Assistance, or BLC program, to assist equity entrepreneurs in the city of Los Angeles with obtaining a commercial cannabis license and operating a successful cannabis business. This series is part of broader BLC program efforts, which also include live webinars with different subjects and experts, networking events to connect you with other local LA businesses and industry leaders, checklists, worksheets, and other management tools you can download and use, self-directed online education on important topics related to running a successful cannabis business, which is hosted through the BLC's Learning Management System, which is usually referred to as the LMS. And we also have a robust coaching program that connects applicants with seasoned cannabis subject matter experts. We're going to drop a link in the chat now for you so you can sign up for these really vital coaching services. Please visit cannabis.lacity.org for more announcements on our ever-expanding BLC program. And please RSVP today to attend the LA Cannabis Unite event at the historic Mayfair Hotel on June 17th. Social equity businesses who are in operation are welcome to have a table, and you can also participate in supply chain speed dating from 3 to 5 p.m. So what is supply chain speed dating? Well, the goal of supply chain speed dating is to have social equity brands and products on dispensary shelves. Social equity operators will meet with cannabis industry distributors and brands to sell your products to industry buyers from various licensed California businesses and distributors. Supply chain speed dating is a great way to meet other folks, and this event will be crucial to the expansion of your network, and it's going to help get your products in front of consumers. If you want a table, which is only for social equity operators, or if you want to register for speed dating, please fill out the registration link we are dropping in the chat right now. If you only want to attend, which is great as well, you can RSVP at EventHigh in the second link we're about to drop into the chat. DCR services will be on site and available too. As part of the city's social equity program, DCR has launched the BLC LMS portal, where you now have access to these recorded webinars and online courses and digital resources made especially for you. Information on how to access this LMS will be in the chat. Also, please note that there is a module in the LMS that will be live on this topic of tonight's panel discussion in a few weeks, and it is called Understanding Operating Agreements. This module is extremely comprehensive and covers many additional topics about operating agreements, LLC corporate governance, and considerations of social equity operators than we're going to have time to cover tonight. I highly recommend that you take this course, and it's launching very soon. So before we get started, let's take a moment to review some housekeeping rules. Please note that this webinar is being recorded and can be viewed after the editing process on DCR's website. You will be muted with cameras off for the duration of the webinar. This means that your camera and audio functions will not be available during this session. You will be able to see and hear all the panelists, however. There is an open chat box where you can interact with one another for networking or comment on the information. And please use caution when sharing personal information in a public forum, and keep your questions focused on tonight's topic. Please ask questions about tonight's subject matter in the Q&A box. We are gathering and responding to your questions throughout the presentation, and we will have a dedicated Q&A session if there's time at the end of tonight's panel. So you are encouraged to utilize the Q&A box at the bottom pane of your Zoom screen, and if you use the Q&A box for your questions, everyone can see the answers to them. And if you have a question, I bet you many other folks likely have the same one. We have a lot of questions prepared for this panel tonight, so we will be hitting the audience questions towards the end of the night if there is time. Please keep in mind that this is a public forum, so we will not be answering any questions about your specific legal situation. And finally, please note that tonight's content was not created by the Department of Cannabis Regulation or the City of Los Angeles, and it is for informational purposes only. This information is subject to change, and it does not replace or supersede the Los Angeles Municipal Code, nor does it constitute legal advice. If you have specific questions outside of tonight's topic, please call 213-978-0738 during business hours, which is Monday through Thursday from 10 a.m. to 4 p.m. to speak to a DCR representative. Now, let's start this panel discussion off, but please give me a moment to start tonight's presentation. And if all of our panelists want to go ahead and come on screen, that would be great. All right, good evening, everybody. Hello, hello. Okay, all right, so our first, it is my esteemed pleasure to introduce tonight's panelists. And while they are all expert lawyers and attorneys, I want to remind you, everyone in the audience, they are not your attorney. So let's keep that in mind for tonight's discussion. First up is Shay Gilmore. Shay Erin Gilmore advises and counsels exclusively cannabis operators and investors through the corporate, commercial, and regulatory complexities of California's legal cannabis markets. Shay focuses on private mergers and acquisitions, joint ventures, private equity financings, cannabis distribution and supply agreements, cannabis licensing and product development, and regulatory compliance matters. Shay has been recognized by the Los Angeles/San Francisco Daily Journal, the state's largest legal news periodical, as one of the top 20 cannabis lawyers in California. Super Lawyers magazine has named Shay a Northern California super lawyer in cannabis law and in business and corporate law. Shay serves as a member of the board of directors of the International Cannabis Bar Association and as the immediate past chair of the Bar Association of San Francisco Cannabis Law Section, where Shay organized the first group of volunteer attorneys to provide pro bono legal services to social equity individuals verified under San Francisco's Cannabis Equity Program. Shay holds a BA in economics from Rice University and a JD from the University of Texas School of Law. So excited to have Shay this evening. Up next is Kieran Ringenberg. Kieran joined Feuerstein Kulik LLP in 2022 and leads its office in Oakland, California. Kieran has focused his work on cannabis industry clients since 2016 and represents many of the industry leaders, including cultivators, manufacturers, distributors, and retailers. Kieran's work includes complex regulatory and compliance issues. He is one of the few lawyers to represent licensees in contested administrative proceedings under the state's cannabis regulatory system. He has also served as an expert witness on state and local cannabis regulatory issues. Relying on his 2 decades of litigation experience, he also regularly handles significant litigations in the cannabis space. This includes thorny ownership and control disputes, aka operating agreement land, where cannabis licensing and regulatory issues are central, real estate controversies involving cannabis licensing, and intellectual property disputes arising from cannabis products. Kieran also brings his subject matter expertise to advise on mergers, acquisitions, and other transactions. Kieran has regularly been asked to educate lawyers and business leaders on cannabis issues, and he's been featured in numerous media outlets and podcasts. Kieran graduated from NYU School of Law, where he was executive editor of the NYU Law Review, and after law school, he clerked for Pasco M. Bowman of the United States Court of Appeals for the 8th Circuit. Up next, we've got Zach Knox. Mr. Knox has been practicing law in the cannabis industry for 12 years. He is a co-founder and the managing partner of the Knox and Ross Law Group, which was established in the city of Oakland in 2012. Mr. Knox is intimately familiar with the California cannabis industry and is nationally recognized as an expert in the field of cannabis law and regulation. Mr. Knox previously served for several years on the City of Oakland's Cannabis Regulatory Commission, and his firm, the Knox and Ross Law Group, has been the contract legal services provider for the City of Oakland's Cannabis Technical Assistance Program since 2017. Mr. Knox's dedication and commitment to supporting equity is evidenced by his continued efforts to improve the equity programs across California and outside of the state, as well as his work with other equity support organizations such as the Cannabis Health Equity Movement, or CHEM. All of y'all should check out CHEM, it's amazing. And the Alliance Inc., which is a California nonprofit organization focused on education and training of underserved communities. And last but certainly not least is Jessica McElfresh. Jessica C. McElfresh of McElfresh Law Inc. has worked in cannabis law and policy since 2010. She is the chair of the International Cannabis Bar Association's Professional Responsibility and Ethics Committee and is a member of its board of directors. Jessica focuses on local and state applications, land use, regulatory compliance, and business law for cannabis licensees. She has authored or advised on ballot measures to regulate cannabis businesses, including Measure U and La Mesa, Measure V and Lemon Grove, and Measure H and Encinitas. Jessica represents people facing discipline or loss of state and local licenses, particularly in the cannabis industry, and she has unique experience with the crime fraud exception to attorney-client privilege and the duties of an attorney under investigation or facing criminal charges. Jessica grew up in San Diego and graduated summa cum laude from Scripps College before attending the University of San Diego School of Law on a Dean's Honor Scholarship. She's spoken at conferences and taught continuing legal education classes for organizations and law schools, including the California Lawyers Association, Practicing Law Institute, the International Cannabis Bar Association, the San Diego County Bar Association, and the University. Before we start, let's few key kick off tonight's conversation. So we're all here to talk about operating agreements. So what is an operating agreement? An operating agreement is a document that outlines how specific activities will be performed and how major decisions will be made during the operation of a specific type of business called a limited liability company, or LLC. Tonight's webinar will be a discussion among our panelists about topics related to the use and drafting of operating agreements. And our discussion will specifically focus on the unique considerations of social equity operators who are members of an LLC. There's a lot of specific terminology used when discussing operating agreements, so let's check out a few of those key terms now. As I just noted, there's just a lot of specific terminology used to discuss operating agreements. So let's review some of the most important terms and their definitions now. You may want to take a screenshot of this slide to reference back to it during the panelist discussion. So let's hit these terms. First off, members. Members are the owners of an LLC. Membership units. This is the percentage of an LLC that one member owns, and this is similar to the concept of shares, which corporations issue. Member managed and manager managed. These are the two types of management structures that an LLC can select to run their business. Organization. This is the term used to describe the collection of members of an LLC. Distributions. These are payments made to LLC members. Initial contribution. This is the amount of cash and assets a member contributes to the startup of an LLC. Capital calls. These are additional funding requests issued to LLC members. Transfers. This is how membership units are exchanged between LLC members. And provision. These are specific topics detailed in an operating agreement. Again, you may want to take a screenshot of this slide to reference tonight, but rest assured, the panelists will be breaking down these concepts during our discussion this evening. All right, I'm excited. Let's get ready to go into our panel questions. So I'd like to kick off our panel discussion with a general one. What is the purpose of an operating agreement? And how does an operating agreement align the members of an LLC? Let's start our discussion with Zach.
Thank you, Natalie. So the purpose of an operating agreement, I would say that it serves a number of functions that in any other business entity you might accomplish with several different documents, right? It is the single unified document for an LLC that provides for its governance. It establishes the relationship amongst the partners or the members, if you will, amongst themselves, as well as between them and the LLC. It provides a breakdown for how voting will be handled amongst the members, how economic participation will be metered out and apportioned amongst the members. There's any number of other additional things that could be addressed in an operating agreement, but I think the general idea is that all the high level agreements that need to take place between the members and the LLC itself are usually contained in this one document.
Great. And how do you find operating agreements align the members of an LLC? Or maybe it doesn't always do that, but let's hear a little bit of your thoughts on that, Zach.
I think it's a great point to bring up, because the members' interests don't always align.
Yep.
And so I think part of negotiating the operating agreement is trying to bring the members into an alignment as much as possible. It's very easy to be aligned about the mission of a business, particularly early on. Everybody's excited. Everybody believes the business is going to be successful, but they may have different motivations for participation. They may have different ideas about when they might want to exit out of the business. When you're talking about capital partners, what sort of returns they might be seeking out the business, and the priority of those returns may be different than other members in the business. So the operating agreement, I think putting one together is the effort to try to bring everybody to the table and get them on the same page. And to the extent that they are not completely in alignment, to set up a framework for how disagreements can be resolved and disputes can be handled.
Thank you for that. Who's up next? Anyone have some more thoughts they want to share with us about the purpose of an operating agreement and how it aligns LLC members, or maybe it doesn't? Jessica.
Yeah, I would add, I think Zach's explanation is far more elegant than mine, but I've always found with clients that the operating agreement process, negotiating it, talking about it, going through those things, I think it's only fair to disclose I've never been married, but to me, it's a little bit like a prenuptial agreement in a way. It may, kind of like sometimes discussing one of those, it may head off a partnership or a relationship that maybe shouldn't occur, because if you as business partners can't have an initial constructive civil discussion about this, you should not go into business with one another. I don't care how good it seems. So I think it's very valuable that way, because if you can't get through that initial step, how are you going to get through all the other hurdles you're going to have to go through?
That makes sense. When I was doing some research on this topic, I actually had the same thought, Jessica. I was like, it would be so interesting if this was required for marriage. So I totally hear what you're saying. Kieran.
Yeah, I would continue that theme and say, if a business is going to hit struggles, difficult decisions are going to have to be made. And often the owners may not agree on what to do in that circumstance. And it might be because they just have a difference of opinion. It might be because they're differently situated. In the context of a social equity license, where you typically have one capital partner or one or more capital partners, and then the person who brings the social equity eligibility to the table, there's already some fertile ground for disagreements about how things should work. And so the operating agreement is the chance to work out in advance, as best you can, what to do when these situations arise. And kind of echoing Jessica's point, when people are coming to the table and have goodwill and are hoping it will succeed, that's a much better situation to try to figure out how to address a hypothetical situation in the future that may be problematic than once you're in the midst of the crisis. So it's the chance to get out in advance of these problems and say, hey, look, if we need more money, here's how we're going to go about that. If we underestimate how much money this business is going to need to get off the ground, which tends to happen quite a bit in this industry, then here's how we're going to solve that problem. Or if we disagree about how to make a management decision, here's how we're going to address that problem. So it's a chance to solve ahead of time disagreements that may occur, or at least establish a process to do so. Excellent point. Zach?
I just wanted to double down on what Kieran had to say there. I think with regards to timing, I think there's a lot of businesses in this industry that make the mistake of delaying the conversation about putting together an operating agreement, if they even put one together at all. And so I just want to reemphasize what Kieran said: have this conversation early, and don't avoid the tough part of the conversation because you think everybody is getting along early on and you don't want to create any waves. That is the exact appropriate time to have the tough conversation about economic rights, about voting participation, about management, about the involvement in management if you're a social equity qualified individual. You have to have that conversation early. And I think Natalie and just both made a great point that it may clue you in that this is the wrong relationship to get into if you can't get past that point.
Absolutely. All right. Any other final thoughts before we move on to our next question? Okay. All right. So let's go ahead and ask our next question. So now that we understand more about the purpose of an operating agreement and how these documents align members of an LLC, or maybe help folks figure out that coming together to form an LLC is not going to work out, let's move on. What are the unique considerations of social equity operators and how an operating agreement is drafted? And I would like to start this discussion by hearing from Shay.
Thank you, Natalie. And I think the most prevalent consideration that you're going to want to consider that's unique to the social equity operator is the minority status, right? These equity applicants were called VEAs here in San Francisco. They're called whatever.
In LA.
Right,
Yep.
right. I mean, they don't come in as majority stakeholders to these deals. They come in as minority equity stakeholders, sometimes, officer, what have you. And so I think that it's particular to the social equity applicant status, right? That's why it's unique. And I think it's important to think about, because as you've heard people talk already on this panel, there's this, it's a minefield, I guess, of potential disputes. And so you kind of need to, not have fights about stuff that you're not going to win on. And if you're coming in as minority shareholder, you're already coming in at a disadvantage in pretty much every single dispute because you don't have a majority stake. So some of the things that you might want to think about or consider as a minority stakeholder are things like board representation. Some equity programs will actually require a presence on the board or officer position in addition to the equity percentage. Voting rights, these are all negotiable. You might want to think about negotiating for voting rights that are in some way enhanced from the minority position that you take as a social equity operator. Things like defining quorum, right? You can negotiate to have in your agreement that things don't get done unless you're there, right? That's some power that you can bring to the table as a minority stakeholder. Observer rights, your ability to kind of watch what's going on, in the organization that you're a minority stakeholder of. You also want to think about restrictions on competing behavior and kind of how that is, a tool that you can use. Auditing, and I think the big one is obviously restrictions on the issuance or transfer of equity. So you want to think about things like tag-along rights and drag-along rights and provisions in the agreement that have a bearing on your minority stake as an equity holder.
Yeah.
And I don't mean social equity, I mean like business equity, ownership equity.
I just want to pause for 1 second, Shay, just because all the social equity operators in LA are required to own 51% or more of the company. But I think everything you just said is still absolutely critical to their considerations and how their operating agreement is drafted, because we need to make sure that they have all of this representation, like you said. And I'd love if you could maybe break down drag along rights and tag along rights for our audience, just so we're all on the same page with some of these complex terms.
Yeah, even if you come in as a 51%, you don't get to, I mean, you should recognize that you have ultimate control over all these decisions here, but you're going to be like negotiating against people that are going to have like, I don't know, ways to buy into your control by like, putting up all the capital that they've got and all the sophisticated knowledge. But I mean, what I would say is for the 51% shareholders, know your value. I mean, look, right? I mean, you're at the table, know your value if you're 51%. We don't have in San Francisco, we're different. And so it works out. The deals look different, right? And we actually have like a program going here in San Francisco until next year that requires whenever there's a change in the ownership of the LLC, that drops the percentage of the equity applicant, that the company has to undertake all these reparative measures. Like, donation of technical assistance and financial assistance and that kind of thing. So anyway, but point is, like other panelists were saying, this is a negotiation. And even if you come in as a 51%, you're still coming in at a disadvantage because you're coming in against other players that are adverse to you potentially, and that have a lot more experience and capital to bring to bear. Drag along rights, really simple. That's the right of the majority to compel minority stakeholders to sell their stake in the company at a predetermined price. Tag along rights is the reverse. It's your ability as a minority stakeholder to go ahead and grab on to any deal that you see benefiting the majority stakeholders.
Thank you for that. Zach, I saw your hand was just raised.
Yeah, I think Shay was doing a great job of diving into a number of the different sort of provisions that you would find in an operating agreement that are meant to either protect your rights as an owner or establish obligations that the members owe to you. I sort of look at this question in two buckets with regard to social equity. You're trying to preserve your economic participation in this business. And depending on the level of involvement you want to have in operations, you're trying to preserve your participation in the decision-making process. And there might be a number of different tools in the operating agreement toolkit that are intended to do that, right? So Shay brought up the example of tag-along rights and drag-along rights. And where this really comes up is if there is a deal on the table from a third party to buy out your company. And this is one of the more common exits for operators in this industry. They come on and their business gets acquired. There are challenges around that with equity because there are usually regulatory restrictions on the transfers of equity interest. But you may still want to see these provisions in your operating agreement just in case the law or the regulations around that ever ease up. So I think the significance there is when a deal comes and it's on the table, you don't necessarily want your partners to bail out and cash out their interest and leave you stuck with new partners. And so the tag-along rights there would allow you to preserve your economic participation in that deal. And the same thing with drag along. I mean, if maybe you're the one who finds the deal, right? And you now need to convince your partners to come on board for you to be able to take advantage of that exit. And so, I look at those two provisions as being important to your ability to preserve your economic participation. But I think that you can look at any number of these provisions that we're probably going to talk about in the operating agreement. And at the end of the day, they're either meant to, preserve or provide your participation around decision making in some capacity, or your participation in the economic benefit of the business.
Those are all great points. All right, Kieran, let's hear from you.
So I'm going to come at this from a slightly different point of view. I agree in these negotiations between, assuming we're talking about like a social equity eligible individual and their capital partners or whoever the other partners are in the business. You want to do what you can to preserve your situation and the value that you're bringing to the table, 100%. On the other side of the coin, you're trying to build a business that's going to succeed in the long run. And the social equity programs, for very good reasons, impose restrictions on the business. So at least at Current, for example, there's a certain ownership that is required, certain profit distributions are required, and certain voting rights are required by the regulatory system. And that places some handcuffs on the business, on what it can do. And so one of the things you have to think about in working out the operating agreement is how do those restrictions, how are you going to deal with those restrictions in practice? So just as an example, capital partner brings in a certain amount of money, they're going to get 49% of the business. The social equity person gets 51%. That's the regulatory requirement. What happens if more money is needed? What are you going to do? Right. So the fact that you can't just bring on a new equity partner and dilute everyone in the business evenly, that's kind of would be normally what you do is like, hey, we're out of money. We need to go raise some. Let's go sell equity. Everyone would get diluted equally would be the normal course. That's not allowed in this context, at least under the current regs, generally speaking. So you got to figure out how to deal with that. So as you think through these problems, it's not just a zero-sum game where you're trying to make sure you're protected and your partners are not. You also want to make sure that you're setting up structures so that the business can operate and has the flexibility it needs to go forward. That doesn't mean giving up your rights, absolutely not. But it does mean thinking creatively about, hey, what happens if we come to this? Asking your equity, your capital partners, for example, to say, hey, look, if more funds are needed, how are we going to do that? Because I can't sell my equity, you can. Maybe we could take on debt, but you just have to have that conversation in advance and think through how the program's restrictions tie your hands and allow you to move forward under the current regulatory system.
I think those are all great points. And the panelists are discussing exits a lot. And so for folks not used to that term, an exit strategy is how a company decides to close its business, either by dissolving it and or going through a merger and acquisition, meaning it's being sold to another company or merged with another company. And so we want everyone who is entering into an operating agreement to think through these exits. But as the panelists were saying, due to the unique regulatory structure in social equity programs in cannabis, there isn't any real exit that is possible because we have to maintain our 51% majority ownership by the social equity applicant. But what they're discussing is we need to make sure we're planning for all the possible exits and how the operating agreement is drafted. Zach, I saw you had your hand up again. Did you want to throw some other thoughts there?
Yeah, it was a thought based on Shay's original comment, and I think Kieran just highlighted it again. Yeah, and this is a consideration that I do think is unique to social equity programs. Mm-hmm. And Shay said it best, you have to come into this knowing your value. Yeah. And I think having a clear understanding of the value you bring to the table as the equity qualified individual will help with the sort of planning that Kieran was talking about. I think one of the ways that these capital tables end up getting wrong sized is a lack of recognition around the value that the equity applicant brings. And what we end up seeing half the time is there's a 51 and 49% split between the social equity operator and their capital partner. And you look at the cap table and the initial contribution is something nominal, right? Like $510 and $490. And then all the other capital requirements that the business has are being made through debt with the capital partner. And so these are one of the setups that I try to advise equity operators to avoid. And I think one of the easy ways to start undermining that way of doing things is to get an acknowledgement of your value. I mean, if you're a social equity candidate, not only do you make the business eligible for a license, but you might make the business eligible for fee waivers at the state level definitively, possibly at your local level. You're going to be eligible for technical assistance in the city of Los Angeles. You're going to be eligible for pro bono legal services. All of these things have a monetary value that can be affixed to them, and that value should be recognized as part of your contribution to the company. And I think a lot of the times these cap tables get wrong sized because that value is not being recognized. So I think that's something that is really important for equity operators to consider. And as you're negotiating with your capital partners, to ensure that they acknowledge that contribution and the value it brings.
Great. And Zach, for folks new to the concept of a cap or capitalization table, can you give us a brief description of what that is? And we know this is a document that should hopefully be accompanying an operating agreement among a few other documents.
Yeah, so the cap table is, for better or worse, just a table or a chart that would list the different members of the different owners in an LLC, and it would specify how many membership units they hold, what percentage of ownership those units amount to, and what the value of their initial contribution was that was made in exchange for those units.
Right. All right. Any other thoughts? Jessica, Shay, Karen? Okay, let's go to the next question. Thanks, y'all. So social equity operators certainly have a lot to consider in the operating agreement they enter with the other members of their LLC. And it's always advised to negotiate and finalize an operating agreement at the outset of starting an LLC. And the city of Los Angeles requires that operating agreements are reviewed and deemed compliant with their equity share requirements to pass the local approval needed to receive a state cannabis business license. So what are the consequences of an organization not having a thorough operating agreement in place when they commence operations? And a thorough operating agreement in this context means one that has well outlined dispute resolution processes, among other key topics. I'd like to start this discussion off with Kieran, because he's got a lot of experience litigating.
Yeah, so that's the answer to your question is litigation thrives and breeds where there's uncertainty and unclarity about roles and responsibilities. So if you have a big issue, an elephant in the corner of your operating agreement, addressing an eventuality, what happens when we run out of money? What happens if we lose our lease? What happens if the capital partner doesn't make the contributions that they promised to do? Whatever it is. Something happens that is not clearly and expressly addressed in the operating agreement, then you have two sides fighting about what the right course to do is. Now, having a clear operating agreement that spells out specifically what the parties have agreed in advance to do in these eventualities doesn't mean litigation is not possible. But it does make it less likely, because if you have a clear agreement on what you're going to do in circumstance A, B, and C, then any rational actor looking at that is going to be much less likely to run into court if you can't work it out. That is the answer. The more you can resolve in advance and specifically address the circumstances that have come up, the reduced likelihood that you're going to end up fighting with each other about what to do in that scenario. I will say, in my experience, the vast majority of disputes that make it all the way into litigation happen for one of two reasons. One of which is someone is desperate and they have no other choice than to go to litigation, and they feel like they're going to lose everything as their only chance. Not a lot you can do to head that off. The second is there's a good faith disagreement about what's supposed to happen in that scenario, and the parties just don't see eye to eye, either because they had different understandings that never got put in writing, so they didn't get resolved, or because it's just something they never really talked about, so they had unexpressed assumptions. So the more you can work through those unexpressed assumptions and express them, get agreement on them and put them down in words on a page, the less likely it is that you'll end up fighting with each other later through the very expensive and almost always business consuming process of litigation.
That makes sense. And I hear a lot from folks, that operating agreements, they're just so complicated, they're so long, and a big part of operating agreements is outlining these dispute resolution pathways. So Kieran, can you briefly describe what these pathways are? Usually it's arbitration, mediation, litigation, or taking a vote. So let's
Yeah.
make sure everyone kind of understands these pathways.
You bet. So there's two levels at which this can operate. So the first of which is, how does the company make decisions, right? And there's a couple of levels that happen there. So kind of Roman numeral one is, how does the company make decisions? Subpoint A is, typically there's going to be a board of managers. It doesn't always work that way, but that's the most common structure. If you have any kind of well thought out operating agreement, is you're going to have a certain number of people who are decision makers, and typically they're going to vote on major decisions. So if you have a board of managers, it's akin to a board of directors of a corporation, and there are a group of people that votes. Hopefully you have an odd number of them, because otherwise it's very difficult to make decisions if people don't agree. And if there's a dispute about what the company should do, a disagreement among the partners
Yes,
about what the company should do,
Hello, is this Miss Payne?
you'll
Yes, this is Donna
you'll have
Brown.
that
I'm calling
board.
in response to your
I'm so
inquiry.
sorry, Karen. One
problem.
second, please.
No
We'll
problem.
make sure that gets muted. Okay, that's muted. Go
There-
for
there-
it. Apologies
There you
for
go.
that.
You'll have a vote among that group. The second level is, often in an operating agreement, the members or owners may have a direct vote based on their ownership share on certain decisions. So typically an operating agreement is going to set out, there's fundamental decisions that the board can't make that only the owners can make by voting. And you'll set out what percentage of owners' approval is required for certain actions. So for example, typically to dissolve a company, you're going to have the members vote, and you're going to have a supermajority if you're just ready to give up on the beast, just as one example. So the first thing is your operating agreement is going to set forth all that. You're like, hey, if we need to make a decision as a company, how are we going to do that at those levels? Then you get to a problem. Okay, what if everyone's not on the same page? And notwithstanding those processes that we set out, if someone's talking about bringing a lawsuit, or at least they're not willing to go along with the team on the decision that's been made under the rules that we agreed on in advance, what do you do? So that's where we have dispute resolution mechanisms. And I would say typically in cannabis deals, you're going to see a negotiation phase where you have the parties agree they're going to work together to try to work it out in some negotiated capacity. Perhaps that involves a third party, typically called a mediator, who is an external party who you bring in not to make decisions, but to facilitate a conversation between the parties to try to reach agreement if there is an agreement that can be reached. Often that's a fruitful process. It can be a little expensive and time consuming, but it's much less expensive and time consuming than a lawsuit. So it's often money well spent. And then if you can't resolve that, then where is the forum? You decide, you submit your dispute to a neutral decision maker to have them decide who's right and who's wrong. And the default in our legal system is you go to court. If these businesses are in Los Angeles, typically they're going to be in Los Angeles County Superior Court. The parties can't agree either in advance in the operating agreement or at the time of the dispute to instead send it to a private decision maker. We call that arbitration. And that often can be a faster and less expensive process. It's also a private process, which can have benefits in the cannabis industry. And so that's what you'll see. I think a well-crafted mediation and arbitration dispute resolution process can get the parties to a resolution of a disputed issue faster, cheaper, and possibly even more predictably than a lawsuit in court could be. But that's not true in every case. It really does depend on your decision maker. So that's kind of the range of the constellation of processes that you're talking about there.
Great. And so, one of the reasons why operating agreements are just so detailed is because we have to have these resolution pathways well explained, and people will be really grateful that they're there if they run into these issues.
Absolutely.
I'd love to hear from someone else. Any thoughts on, what is a thorough operating agreement? Is there anything else we want to throw in there, and despite, or in addition to dispute resolution? Go for it, Zach.
So, I mean, there's a number of things that you could say would be in the list of what would constitute a thorough operating agreement. What I just want to impress upon the audience is the need to try to be comprehensive. Sometimes I've come across these operating agreements that someone may have downloaded off Google, or who knows, they might be using ChatGPT now to draft operating agreements. And what I want to caution folks of is that if there is something that your operating agreement doesn't address, it's a template agreement that you pulled from somewhere else, and it doesn't address everything that it may need to address, even if there is dispute resolution provisions in there. If there are matters that are not addressed, you run the risk that your operating agreement may default in some areas to state law. and state law may be in conflict with some of the requirements established under these equity programs. So I think it's useful not only to try to be comprehensive in your operating agreement, but I think that's also a call for making sure that you get legal review and legal assistance before you execute the agreement to make sure that all these bases are covered.
Absolutely. And in the equity share review process for LA, they will be reviewing the operating agreement. There's many things that need to be in there. And so a template will never suffice, at least without significant customization for any business. Jessica, go for it.
Yeah, I would say, I mean, comprehensive is a big word. I mean, we are not able to anticipate every conceivable situation. But along with legal review, what I really think matters is comprehension. And this is not a problem. This is a human problem. A lot of people, they read these things and look, I'll level with you. Some lawyers stink. They make things way too long. They use words that make my head hurt. It's always read this here and then jump up here and then jump over here and put an umbrella on your head or whatever. I mean, I swear to God, some of them are overly complicated. And at times, some of them really remind me of what a colleague of mine once said about certain agreements, which is, well, those lawyers practice in buildings with a lot of extra stories, so they have to add about another 20 pages for every additional story in the building. It's just true, guys. Now, having said that, please, I agree. Don't just download something from the internet. It is a bad idea. But there is nothing wrong with whether it is your deal lawyer, your own independent lawyer. You do want to sit down with this document with somebody who is your lawyer, who is going to give you your legal advice, not your buddy's mechanic's lawyer, okay? Somebody who is going to give this time one way or another and just say, what does this mean? What does that mean? Put this into English. It is good to just sit there with the document and do that. And this last part's not nice, but maybe you just have one of those really terrible, awful agreements that I and even Shay hates. He's got way more patience for this stuff than I do. But if you can't get through that and you can't sit there with somebody to read about it, I pity you when you begin to read the state's tax regulations and other and the day-to-day DCC regulations for running your business. I mean, I hate to say this, guys. There's only going to be more paperwork and more pain and more reading. And there's nothing wrong with wanting somebody to study it with you. We all benefit from it. I'm going to tell you the truth. Lawyers call each other and be like, are you reading this one the same way? Is this kind of crazy when you put this in here? Like, what is this? That's normal, but please don't blow it off. Don't assume because the city's reading it that it's going to be fine and you're going to be protected. Don't assume it's got everything in there. Your comprehension of this comprehensive document really matters.
Great advice. Thank you, Jessica. Shay, love to hear from you.
Yeah, I would just add quickly that another consequence that I was thinking of as I was listening to all these really thoughtful answers is missed opportunities, right? When there's investors coming in to the space, they want to know what it is that they're getting in terms of their ownership in the business. Well, that's the kind of thing a thorough operating agreement will describe, and in particular, how new members are allowed to come in. Now, of course, there's like regulatory requirements that we've talked about, and San Francisco has our own little experiment going, and everyone's got their own in California. But regardless of where you are, if you don't have a thorough operating agreement describing how those transfers of shares roll out in the event of any investment, you're less attractive as a potential investment target for outside participants.
And that's really critical, because obviously we know that there's a lot of barriers to social equity businesses face, but one of particular importance is finding the needed investment, right? So making sure that the operating agreement is structured so that people can see the value, like you said, Shay, I think is really key. This was all great advice. All right, we're going to move on to the next question. So before we go into our next discussion, let's revisit one of our terms again, provision. So provisions are specific topics addressed in an operating agreement, and they generally cover important activities such as how profits and losses will be allocated to members, how much money / assets each member is bringing to the LLC, the purpose of the LLC, and pathways for dispute resolution, and much more. So we've heard a lot this evening about how operating agreements structure the activities of LLCs, but there are also so many economic pressures and regulations that influence how operating agreements are drafted. So our next question to the panel is, how has the capital required to start cannabis businesses, in addition to the requirements of social equity programs, influenced the types of provisions commonly found in operating agreements? And I'd like to kick off this discussion with Jessica, please.
Sure. Well, I don't know if I can square this within the structure of an operating agreement better than we already have, but I do have to say this. I personally don't like this fact about the world. However, it is extremely expensive to start a cannabis business. And I agree with what Zach said. Social equity applicants are bringing real value to the table that goes beyond the eligibility for a license. It can be tax incentives, support, reductions in fees. However, this is an incredibly competitive industry, and these businesses cost a lot of money to start. And I've been at this for 13 years, and I have, when I first started my career, I mean, every person who came to me, they just really, and I know how this is going to sound a little silly, but they just really wanted to run a cannabis business.
Yeah.
Like they wanted to be, I know, it's so cute. They wanted to be behind the counter. They wanted to be selling things. They wanted to be doing this. They were like so many small business owners that you meet. And I'll be honest, I still work with some of those people, and some of them had a lot of success, and it's been a really interesting journey with them as they've sold companies and started new ones. But eventually people started showing up, and these people had money. And it's not that that was a bad thing. As I've said, this is very expensive and very competitive. But the problem with people who bring in money is they didn't always want to actually run businesses, was what I found, that they wanted return on their investment. This is not a problem unique to any business. That's the problem with needing capital. And I think everybody's given good advice about how to consider those things, how to talk about them when you're putting it together. But what I keep coming back to with some of this is, and I think honestly, this constant discussion about exits, or let's just call it what it is, selling your company in X number of years, usually. I think it even can sort of taint these discussions from the beginning, because when you're talking to somebody, that may not happen to you. I hate to break it to you, but it may not. But on a serious note, I think that where this starts is kind of back at the beginning, and how is this going to work? And yes, there's all these pieces and all these drag-alongs and tag-alongs, and even these things called shotgun provisions, and those are really mean. But on a serious note, this is really not that different than what some of my clients started out with, which is, I want to run a store, or I want to do this, I want to do that. I need capital, I need investment. And there's always been some dynamic within some of these businesses of the person who was going to bring various advantages, knowledge, experience, that interest in running the business, all those things to the table. That contribution, that equity, those opportunities, all of that you're going to show up and actually make sure things happen, that has incredible value to a business. And if you're not talking to people who want you to do that, who don't want you there, well, I'm sorry, but to heck with them, for starters. But for another, that business is not going to do very well. People need to be there day to day, and they need to be running it. The other reality that comes along with that is, let's say you still want to exit in 5 years or 10 years or whatever, and you're going to do that work. When people come to buy companies, they look at their position, they look at their reputation. They don't just look at the fact they have a license. They look at how successful they are. They look at this thing called EBITDA that just makes my eyes roll over. They look at your reputation within the community. They look at all the things that make a business stand out. Money is huge. And it sets off a bizarre power dynamic in all sorts of businesses, and social equity businesses are in no way unique that way. But what really makes these businesses stand out is who is there day to day, who is putting it together, who is working on the business, who is doing all this. If you are not that person who wants to work to put your business together, to do this, to have these fights, my personal advice is you should let somebody else who does have that interest and desire to do this, because believe me, I've been getting calls from so many people over the years who want to do this, who qualify for various programs, and they just can't attract capital. And I think most people do want that. I think that's why they show up to these meetings, they go through these programs. But that is going to be what makes your business special. That's going to be what gives it value along with the capital. And so finding that mesh with the people you work with, that they want that from you and they see your value from the beginning, along with all these other negotiations and discussions and protections, that's going to be a crucial component. And also with somebody who owns 51%, you've got a lot of skin in that game. Not you have usually the deciding vote on most things, although again, lawyers are tricky people. But you know, that's you. That's you and yourself and you and who you show up with. You have a lot of power, and you want to find business partners that are going to respect that.
That's great. That's great advice. And in terms of how that would be in the provisions of an operating agreement, I'm assuming these would all kind of fall within the manager managed versus member managed sort of realm, and at least defining people's roles and activities from the outset. And that's the crucial part. Okay, Zach, go for it. Love to hear what you got to say.
Yeah, so I agree with everything Jessica said. I think that's a crucial part of it. I think as a social equity candidate, you need to decide what role you're looking for in the business. And when you go out and find partners or investors or team members and you build up your organization, you need to go out and bring in the skill sets that are going to allow you to play the role that you want to play. If you're not going to, this should not be a hobby, right? This is a business now. And if you don't have the wherewithal or the skill set to run day-to-day operations, then you should be looking to partner with somebody who can jump in and handle that side of it for you. But saying that, I do think one of the critical things to point out in relation to this question is getting back to the perception of value that each partner is bringing to the table. This is where I think social equity has kind of turned things on its head, and capital partners, particular private equity capital, are not used to having the sort of limitations around their investment that social equity companies require. Right. So oftentimes there's a perception on their part that the social equity applicant is not bringing value. And so they commonly have it in their head, well, I'm doing all of the contribution here. I'm the one who's at financial risk. And so because of that, I need control and I need preferential treatment in terms of distributions. I need preferential treatment on exits or in voting control. And I think this misperception about value, this attitude that the capital partner is contributing everything, has led to a lot of the predatory behavior that we've seen in how these operating agreements get drafted. And you know, I'm not the one to get on here and say that there isn't room for preferential treatment. Again, you have to create an environment that is going to attract investment here. But at the same time, sometimes the ask of those capital partners are so extensive that they begin to cross the line into predatory behavior, whether you're talking about exits, whether you're talking about additional capital calls, whether they're talking about impugning an equity member's voting participation if they can't meet additional capital calls. Capital partners who insist on setting venue for disputes outside the state. We've seen that with some MSOs. And so there's a number of things that can end up in these agreements that I think are largely driven by their view in terms of the value of the contributions made.
Yeah, that's very, very interesting and sobering point for sure. Shay, what would you like to throw in here?
Just real quickly, I mean, in San Francisco, where a lot of my work is, I mean, honestly, it's just like what my panelists have been talking about here. The capital required drives what's in these agreements, and the provisions that are found in there. And like I think Karen was saying earlier about the social equity program requirements themselves are kind of tilting otherwise reasonable parties in different, maybe unreasonable directions to compensate for these requirements, these restrictions, the handcuffs that Karen was talking about earlier. I would just point out in San Francisco, we've got a temporary ordinance in place that really makes it unappealing to dilute equity applicants' stake. And so, you've definitely seen agreements more recently that, have different provisions in there in reaction to that ordinance. So I'd say how directly and all the time.
Yes, and again, in the equity share review process in LA, they're going to be reviewing specifically for any provisions that could actually dilute or take away or impugn, as Zach said, very fancy legal word, all of these rights that the social equity licensee is supposed to have, and they can't take away their voting rights or their economic participation. And so, the equity share review process is critical to the agency of social equity applicants in these operating agreements, within these programs within LA. Karen.
So I want to make one quick point, which I think needs to be made, which is there is another thing that the capital requirements drive in these deals, which is sometimes pressure from the capital partners to ask the social equity partners to agree to a deal other than the official deal that they're going to tell the government about. And I'm going to, my advice has consistently been to people on both sides of that discussion, don't do it for the following reasons. One, if the government finds out you did this, you're putting the whole ball of wax at risk. And two, it's not enforceable anyway. If there's a secret side deal, if you get into a fight, the secret side deal is going to get shredded by whatever decision maker there is. So it's pointless. You need to sit down and work it out in a way that complies with the regulations and you can tell the government about it. Otherwise, you're just wasting your time.
No, great point. Great point. Truth teller right there. All right, let's move on to our next question. So I hear from members of LLCs quite often, and we've kind of already touched on this tonight, that they struggle to understand both the language to use in operating agreements and the reasons why these documents are so lengthy. Many folks wish they were written in more plain language and that they were shorter, especially given the high costs of executing them. So what pieces of advice can the panel offer to social equity entrepreneurs around the drafting and negotiation process of executing an operating agreement? We would also be grateful to hear any strategies y'all can offer to reduce the cost of drafting an operating agreement from an attorney's perspective. I'm going to open this discussion up to the first panelist who wants to jump on offering up this advice.
I'll go. Yeah, I think for me, the key point, if you're trying to reduce the cost of having an operating agreement drafted, is that the partners need to talk early and often. They need to hash all these things out. They need to discuss as many possible scenarios as they can conceive of. I'll tell you from my own process in my office, if you can come into my office and the more issues on the checklist that you have checked, the easier and faster the drafting process is. Invariably, if we are raising issues that you haven't thought about, that is another area where there could be disagreement that could create back and forth in the negotiation process. It could lead to having to draft multiple versions of the agreement. All of these things are running up your bill. So I think the earlier you can get to talking, the more often that you can talk, and you can start identifying areas of agreement that will make the process a lot smoother and a lot faster.
Great advice. Jessica.
Yeah, I agree with everything Zach just said, including the talking. The other piece of that is at times as drafts are going back and forth, if your lawyer and the other lawyer, if they tell you, you guys really need to talk about something, that there's probably more than one way to work it out. We really do mean it. That doesn't just mean we're tired of you for the day. Like, we really mean that there's legitimate choice, negotiation to be had, and you need to talk to each other. The one that's really hard to contain for is hopefully the other lawyer isn't a word I shouldn't say in formal situations. I'm sorry to say that is inevitably going to drive up your costs for a lot of different reasons. Sorry, it's just true. And you need to consider that when you hire your own counsel. I know you think I'm going to hire the meanest, nastiest bulldog on the block, and he's going to tear all these puppies to pieces. Let me tell you, friend, he's going to run up your bill. Or she is going to run up your bill. It's just
Or
the
they
truth.
are going to run up your bill.
Yes,
Yeah.
yes, whomever.
Pick your
It's
pronoun.
not, yeah, exactly. I'm sorry, but that is usually what comes along with that. The last piece, and this one is getting really granular in a way. I love when clients have talked to each other and work things out. I love when they've made bullet lists. I love those things. What I don't love, because it tends to just add to my time, is when people come in with things they pulled off the internet that then they tried to modify and they tried to write. I know you think you're going to save time. I know you think that your cousin's agreement for his mechanic company, apparently I'm just picking on mechanics tonight, was done by a good lawyer. And hey, maybe it was. But I want you guys to understand, cannabis is very special. Social equity law rules are very special. And some of this just adds a lot of extra complexity. I know you're trying to save time, and I know you think you're going to make my life better. You're not. Please let me and Shay or Zach or Kieran or whomever, please let us do our jobs and do the drafting. And again, I can't emphasize this enough. If you don't understand what something says, don't be afraid to tell me to put it in plain English. Don't be afraid to ask any lawyer to do that.
Great advice. But I did hear bullet lists are helpful. So just letting your attorney know, letting your lawyer know what your goals are and outlining that, but not trying to write the contractual language yourself. Good advice. Heard. Shay, go for it.
So I would just, I agree with everything that my colleagues just said. I would say, think about maybe a 3-step process as my advice. First, identify all the areas of potential conflict, like access to IP, future financing, acquisitions, all the things we've talked about here. Then think about dividing these areas of conflict into 3 categories. First category, matters over which the minority party, that's the not 51% party, requires a veto. They cannot get in this deal without having a veto as a minority stakeholder. First category. Second category, matters over which the minority party should have a positive right of action. For example, appointing or removing directors to a corp, but this is an LLC, so it'd be the manager or the board of managers or whatever. And then third, matters on which a majority vote is acceptable. There are going to be a lot of things that are just acceptable because majority rules. That should be like a separate bucket of like areas of potential conflicts that probably you just don't really need to worry about. And then I think you really at the end, you want to make sure that you're recognizing the different functions that the board of managers has versus the members in a manager controlled LLC. They've got duties, right, to act in the best interests of the members. And the members, can kind of, to some extent, act in their own self-interest. So you want to think about how those different roles of these players inside an LLC can really influence the ultimate, resolution of any potential dispute or the outcome of any opportunity.
That's great advice. And figuring this out first before you go to the drafting process, negotiation process, will really speed it up. Is that sort of the gist of that, Shay? Yes. All right. Kieran, go for it.
I have one more thing to add, which is and I feel like I'm fixated on this in all my comments, but the disputes about money are going to be like the majority of the issues. And so if you can come in with a budget that the parties have agreed to about what you expect things are going to cost and how you're going to pay for them to get the business off the ground to the point where it's financially self-sustaining, that will go a long way to addressing the vast majority of the issues that can take a lot of the lawyer's time in preparing the operating agreement. You know, my preferred practice is if there's any kind, if it's a new business, and if they're far along at all in planning the actual launch of the business, they can have a clear idea of what the money is going to take and where it's going to come from. And if you can agree to that, a budget, and attach it to the operating agreement and say, we're going to run this business within the budget, and here's how we agree or disagree about deviations from the budget and what's going to happen. That's like, I would say like 2/3 of the drama that happens can get headed off. So definitely worth a try if your business is far enough along that you can do that.
Great advice. All right, Jessica.
I love what Karen just said. I could not agree with it more, but 2 comments on that. That budget needs to be realistic and grounded in reality. You may have an overly optimistic take. Your funders can even have an overly optimistic take. It's definitely something, and I know another one of those lovely things lawyers tell you to do is hire an accountant or a bookkeeper or some other type of person who can help you to make these numbers add up. There are also special tax considerations in the cannabis industry, specifically 280E, et cetera, that are going to complicate these things. So that I agree, you need a process, you need numbers, you need a budget. You are also going to need to factor in some play in the joints, a bit of a burn rate, because it's just more competitive than it used to be. But I love the core idea of having a budget. It's just, if it's not based in reality, you're going to immediately have the same problems.
All great points. Zach?
One last point I wanted to make about this, and I thought about this looking at the question again, and it's advice that we would offer to the social equity entrepreneur. So advice we're handing to that side of the equation. And what I would say is, I've seen so many of these operating agreements come across my desk where even if there are generous in the valuation of the equity applicant's contribution, the amount of capital that's being contributed in exchange for equity may not be enough capital to get the business off the ground. And so, you know, the additional capital may have to come from further equity raises, bringing in new partners. It may have to come from debt. And so I think that the equity applicant, if you are thinking about this in terms of how do I get to not the finish line, the starting blocks, right? Opening your doors is the starting blocks. So how do I get to the starting blocks? If my partner has committed to putting up X amount of dollars in the operating agreement, and I know I need X plus, and they're telling me that they're going to provide it, then I have to look at what sort of enforcement mechanism do I have in place? How am I papering up that obligation outside of the operating agreement? So I know this is getting a little bit outside of the scope of what we're talking about tonight, but you know, you may be stuck in a situation where all you have is this operating agreement, which may obligate the capital partner to put in $200,000 when they were telling everybody a month ago that they were going to put in $2 million. Right. So how do you enforce the other $1.8 million that they're supposed to bring in? And that may be outside of the operating agreement. Well, what does that mean for you as a social equity applicant? The operating agreement is not enough to paper up the relationship. And that's where you might have to start looking at other tools in the toolkit. Another thing to talk to an attorney about how to get this done, whether that's a subscription agreement or some other document that creates a funding obligation that would be enforceable even outside the operating agreement.
And if I remember correctly, and that would be the subscription agreement or member purchase agreement, right, Zach?
Yeah, those would be 2 examples of how you could do it.
So the big takeaway is, yes, operating agreements are going to take a long time to execute, but we're also going to need, most likely, several other types of agreements or documents. Zach has mentioned tonight a capitalization table and now also a subscription agreement. Make sure you talk to your attorney about these types of documents and how they may be able to support the formation of the organizing of your LLC, and the funding of your business. All right, this was the hot topic tonight. Jessica, go for it.
Yeah, one other thing, and this all goes into, it's great to have mechanisms to enforce. I agree with Zach. So often what people come to me in all sorts of businesses, it's just not going to be enough. But you know how we've talked about how these people, they think they've got a lot of money. They think they're really important. They undervalue you. They're checking you out. I got news for you. You need to check them out too.
Yeah.
The other thing I learned in my career about people who show up and have bags of money, they're sometimes lying. It's serious. You need to do diligence on these people. They are not all going to be who they say they are. They are not all going to be what they promise to be. And so Zach's right. You need those ways to enforce. You need to work with a lawyer on it. But honestly, you got to make sure they actually have it in the first place. And if they don't want to offer you proof, if they don't want to get into that with you, if they don't want to get naked, so to speak, if you don't want to go to bed with them, I'm just going to leave it there.
Definitely vet people, make sure you understand where they're coming from. And I think that's also a really good way to not waste time on legal fees, right? You want to try to at least have your initial vetting done so that you don't spend all of this time trying to develop an operating agreement just to find out, hey, this partnership isn't going to work for X, Y, and Z reasons. All right, so we're coming to our close of this awesome discussion tonight, and I have just a wrap-up question. I'd love to hear briefly from all the panelists, because I think this is kind of an interesting open-ended question, and I know that you all will all have your own sort of individual take on this. What lessons have we learned since the passage of the Adult Use of Marijuana Act in 2016 as it relates to social equity? And how have these lessons influenced how operating agreements are drafted in the cannabis industry, both historically, but also maybe more especially moving forward? I will turn it to Kieran first.
I think the principal lesson we've learned is that this is a challenging business. There is no easy money to be made, and you really have to have your act together to succeed. And I think there was a philosophy that, hey, if we have limited licenses and we give out some or provide additional benefits to social equity eligible individuals, it's an easy path to business success. And I don't think that's turned out to be true. There's opportunity, but that it's not simple. And so I think what that means is when we negotiate operating agreements to get these businesses off the ground, we have to accept the reality of the challenges ahead and know that we're launching a ship that has a viable path forward. And we've charted a path through the seas that are stormy. And I don't think that's going to get easier. I think it's going to get more challenging as we move forward. And that's the task. We've tried to talk today about what the specific issues are. But I think that's the lesson, is this is harder than I wish it was.
Definitely. Shay, let's hear from you next, please.
Yeah, I back up what Kieran just said there. This is the biggest lesson I think that we've learned, is that this is way harder than we anticipated. And I think that the way that lesson is influencing how the operating agreements are drafted, it's I think it's resulting in a lot of frustration, and I don't think that's unwarranted. And I think that if people can kind of come to these conversations understanding both sides, the majority and the minority equity holders here, right? That's really like, kind of, I mean, you can have multiple owners and how you divvy up the pie, but everyone's going to have their own point of view, and we're all living this in our own way, right? We're all coming to these transactions with our own backgrounds. And so I hope that going forward, we're really intentional about drafting agreements that really reflect the intent that we have and how valuable our contributions are to the enterprise.
Really, really excellent points. Let's go to Zach, please.
Yeah, so I would say the first thing is I totally agree with Kieran and his assessment about what we've learned since 2016. I'm in total agreement that there was a presumption that with the passage of the Adult Use Act, these businesses would be successful, and a similar presumption that if we limited permits and gave social equity applicants a leg up, that their business would be successful. And I agree with Shay that it has forced us, the lessons that we have learned since then have forced us to be much more intentional with our drafting, much more focused on the specific challenges that equity qualified businesses face, whether it's regulatory handcuffs or whether it's different perspectives by incoming partners. And I think that the major lesson going forward in establishing and planning for these businesses, much more broadly than just the drafting of the operating agreement, is that we have to be conscientious of how we want these enterprises to be run, what sort of systems and structures we're going to put in place. Jessica was on point earlier in this presentation saying that you cannot anticipate every different set of circumstances that may come up, but what you can do is to try to build in frameworks, procedures, processes for addressing whatever situation comes up, even if it's unforeseen circumstances. And with the knowledge that you're still not going to be able to fix everything. But I think that, particularly the lawyers who are sitting on this panel tonight have seen enough behavior that, if you're getting sound legal help, you can avoid many of the pitfalls. And I just can't stress how important that is going to be, because I think one of the other things that these programs have set up is a very truncated, a very narrow window to try to negotiate these deals. I mean, if you're talking about storefront dispensaries, a jurisdiction might announce a new round of permits that it's going to issue, and the application is due 30 days later, and they're going to make a decision maybe 60 days after that. And in any other industry, working out agreements with capital partners, working out agreements for, taking control of real estate, these could take 90 days, 6 months. Capital financing can take you more than a year. And only in this industry is it being rushed in a way we see. And I think that's led to bad agreements, and it's led to bad relationships. So that's one of the other takeaways, I think.
All very astute points. All right, Jessica.
Yeah, I definitely agree with all that. And the rushing that's a cannabis problem. It's not just a social equity problem. I mean, it gets exacerbated at times because of the additional complications, but it's a problem. Zach's right. It ain't normal. I think what I think we're learning is we're going to know more each year. There's been a lot, and this is true not just in social equity, it's just true in cannabis regulation, all sorts of things. We're going to know more in a year than we do from now about what is and is not working with social equity programs and how we're going to need to adjust them. Let's say later on tonight, you get your final draft of an operating agreement from Shay, and he sends it over to Zach, and Zach approves it. And everything's great. You guys start, you're going to know more about what you should have had or maybe needed in that operating agreement in a year from now. And for the record, I think they're both amazing. So you're going to have a great operating agreement, but you're just going to know more in a year of actually doing this than you do now. And I think of these programs and the growth of the industry, because there's just always going to be more licenses. There's always going to be more competition. I'm sorry, that's just how this is likely to go. But there's also, you're going to learn more, you're going to know more. And I don't mean that in some cutesy way. We'll be better at this in another year. We're going to be way better at it in 5 years. But in the meantime, you're still going to be here, and you're still going to be trying to sell or cultivate or manufacture or distribute, or hey, maybe even test some cannabis. And you're going to do your best to hold on like everybody else and work those things out with your business partners. And I hope I hope you all succeed. I don't know that that will be true, but I hope that's true. But the thing I've noticed about cannabis is people get into it as an industry and they tell me that they're going to leave. They tell me they're going to sell. They tell me they're never going to come back. They always come back. And trust me, it's exhausting. And the money's not that great as you want to believe. It's good, but it's not as good as you've been led to believe. It's just the truth. But for some reason, people keep coming back. So the good news is we'll know so much more in 5 years. We should come back in 5 years and do this panel again. That'll be awesome.
Yeah.
Yeah, that would be kind of fun. I'm not gonna lie. And we should run this one and then see how wrong we were about so many different things and what we were right about.
Yeah.
And we should also see that Shay doesn't age.
And you also heard a lawyer say that they were potentially wrong. You heard it here, folks.
Oh, I am wrong every day. I just keep going.
I think I think that was a really, really good point, Jessica. And, as we keep on learning more, we're going to get better at how these operating agreements are written. We're going to be able to understand the unique position of social equity operators. We're going to see how things shift, right? If there's one thing we know it's a constant in cannabis, it's change. And with you saying, that you see people come back, and I've seen that too. I have been working in cannabis for almost 20 years now, which is wild. And I do see this a lot where people leave and they come back, and I think it's about the community. And, I think we want to keep that sort of front and center, and the people that we choose to work with, the organizations we form, and the sort of crucial conversations all of these panelists have talked about tonight that need to happen with your other LLC members before you execute your operating agreement. So with that, I want to thank all of you so much. Zach, Shay, Kieran, Jessica, what an absolutely informative, totally interesting, rousing conversation. We got some laughs in, we got some truths in. I really deeply appreciate all of your time and for joining us tonight.
Thank you so much.
Thank you.
Everybody. All right, so thank you for attending this informative webinar offered by the City of Los Angeles Department of Cannabis Regulation. This webinar will be found on DCR's website, cannabis.lacity.org shortly. Also, please remember to check out the module in the BLC LMS that accompanies tonight's webinar called Understanding Operating Agreements that will be in the LA LMS soon. I'm sure there were many points tonight where you're like, that was fascinating. Man, I want to understand that more. This module is really going to help break down so many of the concepts, all the terms, definitions that we talked about tonight. So please, please check out Understanding Operating Agreements. It'll be in the LMS very soon. So now for some fun and networking, please RSVP for the LA Cannabis Unite event at the beautiful Mayfair Hotel on June 17th. If you are an equity entrepreneur and interested in boothing a table, please use the registration link that we are dropping in the chat right now. There are a limited number of tables, so please respond as soon as possible. The afternoon of this event will feature a supply chain speed dating from 3 to 5 p.m. So again, what is that? The goal of supply chain speed is to have social equity brands and products on dispensary shelves. Equity operators will have the opportunity to meet with cannabis industry distributors and brands for the chance to pitch their businesses to industry decision makers. Supply chain speed dating is a great way to meet people, crucial to expanding your network, and it's going to help you get your products in front of consumers. If you are a buyer or seller, please tell us if you want to participate in speed dating by emailing LAUNITE, UNITE, at oaksterdamuniversity.com. I know that's a mouthful of an email address, so we're dropping that in the email and the chat right now. From 5 p.m. onward, the rooftop area will feature a DJ, food, and networking, and there's also going to be a no-host bar available in the lobby. I would also like to alert you to an upcoming educational program being offered by the DCR. Our next webinar is in 2 days, this Thursday, May 18th at 6 p.m. And it will cover the topic of, do I need a business structure? And the guest speaker will be one of the panelists from this evening, Zach Knox. So you know it's going to be informative and a good time. Also, please sign up for the business coaching services offered to LA Equity entrepreneurs. This service is a consultant dedicated to helping your business succeed. You start with a 15-minute phone call to get the help that you need. We're going to drop the link to sign up for this service in the chat right now. If you have any questions on accessing your personal account, please email dcr.scp@lacity.org. I want to thank you again so much for joining us, and I hope you all have a wonderful evening. Take good care.